That there was some bad traffic, so I was giving a little more time for people to get here. But it's hot in here, and you guys are here, so I'm going to start, and as people come in, and the good thing is we record this and we post it so people can see what they may have missed. As I typically do, I'm going to give you a summary of things that have happened recently. There are a lot this time. So I'm sure a lot of people are going to have questions. I'm not going to get into much detail in my summary, but I will open it up for any questions as to what happened. So we had a hearing. I think I told you guys the last time that Prospect was going forward with their motion. They called it a motion of their notice to sue, and in the alternative, they sought the court to give them permission to sue. That motion was heard. That motion was heard in connection with an agreement in which the parties, which would be the receiver on behalf of the plan, the Prospect entities, of which there are 3, as well as Old St. Joe's, Old Roger Williams, and Charter Care Community Board, who we entered into a settlement with, agreed that we would stand down. CCCB would not continue their lawsuit against Prospect. Even if Prospect was prevailed on their motion that was heard a couple of weeks ago, they wouldn't go forward with it. And we wouldn't pursue anything on either way either. The purpose of the motion was to basically get it out of the way. So Prospect said, we want the court to hear the motion. Hopefully the court will rule on it, which the court did not, took it under advisement. And regardless of what the court rules, if it rules in our favor or not, we're not going to appeal anything and we're not going to pursue anything. We just want to get it over with and out of the way. That's what happened. The argument was made, and as I said, the judge at the end of the argument did not issue a decision. He took it what's called under advisement, which means at some point in the future, he may make a decision if it becomes necessary. But as of right now, he has not taken any action on it. I also had my 8th interim report, which went without any great fanfare, just the standard report, of which I think at the time that we last met, there was nothing in that report that you didn't already know, except for one thing. That one thing, which I want to talk about tonight, especially because there were some reports in the newspaper about what it does that I think might have been either unclear or not intentionally, but misleading. I made an election for this plan to be covered under ERISA. That election was made on April 15th. It was a voluntary election. As you all know, the plan has historically been treated like a church plan. As I believe you all also know, I have argued in the federal lawsuit that it should not have been treated as a church plan from at least, let's say for purposes of tonight, 2009 going forward, and each year after 2009, I believe the argument gets stronger that it should not have been a church plan. Under church plan status, and I know many of you have already heard this, you probably know more about ERISA than you ever wanted to know, but under church plan status, church plans are exempt from having to comply with ERISA, which for purposes for you, what that means is that the plan administrator does not need to provide notification of certain actions, and most critically for you, annual recommended benefits or annual contributions to bring the plan as current as possible are not required to be made. It is a recommendation, it is not a requirement if you are exempt under ERISA. There are other issues, but those are really kind of the big ones that impact you. Under ERISA, whether it is a church plan or it is not, if a plan that is exempt elects voluntarily, as I did on April 15th, what that means is that you have to comply with everything that ERISA requires, regardless of whether or not you think you're a church plan or not. Because even if you assume that this is a church plan and it was properly a church plan, right up and through the day that I was appointed as receiver of the plan, if I elect to be bound by ERISA, I'm bound by ERISA. I make that election. The purpose of that election was, in my mind, primarily twofold. The election was done, one, because I believe it was proper. I believe that the plan is an ERISA plan, and at least now, certainly I've argued before that, but at least now it's an ERISA plan. And as a result, I believe the plan needs to comply with ERISA's requirements. I don't need somebody to tell me today that this plan is an ERISA plan. I believe it is. So I think it was necessary and proper for this plan to protect the plan and to protect you and your benefit interest in the plan. That's reason number one. Reason number two is, and this is the area that I believe was either unclear or maybe overstated in the news articles that you read, is that non-ERISA plans do not have insurance coverage and the protections of ERISA. ERISA plans do. By electing to be an ERISA plan, another thing that I did is I made a premium payment to the Pension Benefit Guaranty Corporation, the PBGC. And as we've discussed, the PBGC is similar to an insurance company for pension plans. So by making that premium payment, I've indicated to the federal government, the IRS and the Department of Labor, that I want to be covered under ERISA, and as a result, I'm making my payment to the insurer so that I can be covered, the plan can be covered under the PBGC's coverage. Whether or not that results in anything for this plan, we do not know yet. The reason why we do not know is because we haven't had any determination from anybody as to whether or not it is a church plan, it's not a church plan, what the election means, what it doesn't mean. In addition, the timing of all of this is going to come into play, and it's going to be argued and it's going to be discussed in terms of making the election on April 15th of 2019 and paying a premium to the PBGC. When we know the status of the plan, how does that impact the PBGC coverage? Does the plan get the coverage? Does it get partial coverage? Does it get no coverage? We do not know at this point. My hope, part of the reason, as I said, there were two reasons for doing it. One of the reasons was that I hope we will successfully argue that PBGC coverage, at some point in this case, will argue PBGC coverage should apply to this plan, and that this plan should be protected under the PBGC the way any ERISA plan is protected. That's the ideal scenario for me under the PBGC. There could be some variation of that, but my hope is that PBGC at some level will come in and take over and supplement this plan so that your benefit interest is protected, if not to 100%, a hell of a lot more than it is today. So those are the reasons I did it. I know the paper said that now it's under federal protection, and there's nothing that's, it is a filing. I didn't need permission to make the filing. I did the filing. It was voluntary. It was with the IRS, the Department of Labor, and the premium went to the PBGC, and I received confirmation from the PBGC that they received the money. But that's all we've received thus far. My next step is to have a meeting with the federal agencies, because the plan has been a church plan or treated like a church plan for a number of years. As I said, church plans don't need to comply with ERISA, and so your plan did not comply with ERISA. I had to modify the terms of the plan to bring it in compliance with ERISA, and the election I made was retroactive back to July 1, 2017, which there's no magic to that date except for the fact that the federal agencies and the regulations will not let me go back further than that. I went back as far as I could. But obviously, many of you have been receiving benefits or started receiving benefits in the time between July 1st, 2017 and today. And you were receiving benefits and you had beneficiary designations and all of those things under the old plan, which was not an ERISA plan. So my meeting with the Department of Labor and the IRS is going to be to say, this is what was done with the plan when it was treated like a church plan. This is how we've changed it now so that we're in compliance with ERISA. and we've got a 2-year period that we elected where the changes I made were not in effect. So what do you need me to do to try to fix those problems? Not necessarily fix them, but to do the best that we can to fix them. And so they're going to give me the action plan, I'll call it, that they need from me to bring the retroactive period when the plan was not covered and did not comply with ERISA as close to compliance with ERISA as possible. And as long as I do what they lay out I need to do to ERISAfy the plan or ERISAfy the retroactive period, then they will consider the plan to have been, I guess, cured or cleansed from that during that period from the election in 2017 up to today's date. So I don't mean to damper the mood of what was reported in the paper, because if you read the article in the paper, it was like it's saved, everything's done. The white knight is going to ride in with a bag full of cash and everybody's saved. My hope is that's the eventual result here, but that is a hope at this point that is based on nothing other than what I hope the result of all of these actions will become, as opposed to me knowing that that's what the reactions of the result of these actions will become. So that is the election portion, and I know many of you have questions, and I'll answer those questions as well as I can once we get to that. In addition to the election, we did, as part of the agreement with Prospect, where we said you can have that hearing, but nobody's going to do anything, another part of that agreement with all parties was that we were going to have a mediation session. It was, I will say, as a lawyer, when a judge says, I'm not ordering you, but I strongly suggest that you do this, I take that as an order. We sat in a conference, and both Judge Stern and Judge Smith said, we're not ordering you to mediate, but we strongly suggest that you do it. Like me, every other attorney in that room said, it looks like we need to schedule a mediation with each other. So that's exactly what we did. We chose a mediator who was based out of New York, and he came to Rhode Island on the 16th and 17th, last Thursday and Friday. I was very impressed with the mediator. I will say that. I believe he was a good choice. I think he did a very good job. It was 2 days of mediation. Angel was there. The diocese and those entities were there. Prospect and those entities were there. Obviously, I was there with Attorney Wistow and his attorneys from his office, and even Roger Williams, old St. Joe's, and old CCCB were there. And we spent 2 days with the mediator trying to come to resolution. I'm not surprised, but I was encouraged by the result. We had 2 what I would call good days, and we accomplished a lot, but we did not come to any type of an agreement at the end. Not surprised by that. Where we are right now in the federal litigation, meaning like motions to dismiss haven't been heard and things like that, it doesn't surprise me that we weren't able to mediate the disputes at this time. But there seemed to be a consensus among the parties, although we didn't confer, but the mediator did report back to each one, that all the parties felt that although these past 2 days did not result in a resolution, that the groundwork had been set for that, and that maybe some point in the near future, 3 months, 4 months, 5 months down the road, after certain aspects of the litigation are dealt with and behind us, that the parties will be in a better position to sit down and try again. And the good part is that this mediator has agreed to continue with us if we do decide to do it, which means we don't have to get another person up to speed on what's going on, because quite frankly, getting him to understand everything that had gone on, that took a day in and of itself. There's a lot of moving parts here, a lot of different parties, a lot of different allegations in terms of liability and damages, and he had to wrap his arms around all of that before he could even start to talk about what are we going to do about it. So I walked away, although discouraged, because anytime you spend that much time, you hope to walk away with some result. but my feelings of discouragement were tempered substantially because I didn't really expect a full result after that, and the discussions were cordial and fruitful. Although they didn't result in anything concrete at this point, it set the groundwork for something to be done later on. So that's where the mediation stands. What I can also tell you, I think Julie has had it posted to the website, is on Friday the 17th, Judge Smith entered an order preliminarily approving the settlement with CCF, Charter Care Foundation, and also set for August 29th a hearing on final approval of that settlement. I'm going to say two things about that. Hopefully this will avoid some questions. As you might recall, in the federal litigation, which is a class action, a settlement needs to go through two stages for approval. There's preliminary approval, and then there's final approval. The Charter Care Foundation settlement was approved preliminarily on Friday the 17th of this month. The old St. Joe's Roger Williams CCCB settlement was also given preliminary approval about a month and a half, 2 months ago. The reason why, even though the bigger settlement, the more substantial settlement, has not been set down for final approval, is because there are aspects of that settlement that are still in flux and that parties are still arguing about. And so we all know, the attorneys, me as receiver, and the judge know that we're not ready for final approval because there's going to be objections and arguments, and it's not at that point yet. The Charter Care Foundation settlement, however, is at that point. Many of you were there and recall that there was a lengthy hearing on the Roger Williams CCCB settlement. There was no hearing. Oh, excuse me, I'm hitting the line. There was no hearing at all on the CCF one. It was briefed, and the judge approved it by order without a hearing. So that just gives you an indication of the parties' positions on that settlement versus the other one, which is why final approval has been scheduled on the one that was just recently approved preliminarily, but not yet on the other one. I will tell you that one of the issues with the Roger Williams CCCB St. Joe's settlement, as many of you have heard, is in addition to the cash portion that we're getting, the old entities were assigning and transferring to me certain rights that they believed that they had and certain interests that they believed that they had. One of those is an interest in the Prospect hospitals, which is a 15% ownership interest. Not only does Prospect contend that CCCB didn't have the right to assign that interest to me, there is a very big question as to what the value of that 15% interest is. So until we know what that interest is, and everybody really kind of knows what they're fighting about, that's another reason why that other settlement can't go forward for final approval yet. On that point, I will tell you that CCCB and I have shared names of a valuation expert to help value that 15%. Part of the settlement or the standstill agreement with Prospect was they were finally turned over all the financial information that CCCB had been asking for since September of 2018 on the value of that hospital. CCCB and I have agreed to a valuation expert. CCCB has engaged that valuation expert, and that valuation expert understands and has written into the contract that at some point, ideally, CCCB will be gone and I will be in place. And so whatever work they're doing for CCCB will transfer over to me at such time as CCCB is out of the case. So that value has to happen. I believe CCCB signed the engagement maybe last week, mid-last week, and it'll probably take, on a optimistic side, 45 days, and on a more realistic or conservative side, maybe about 90 days for that group to do the valuation. They have to do it in a couple of ways, so it's not just one formula that they're doing. They're actually looking at a couple of scenarios and giving us numbers based on those. So that's where we are right now. You're up to date in terms of what's been approved. There are no other hearings set other than the August 29th one at this time. We are hopeful now that the mediation try happened and did not result in resolution. We're hopeful that Judge Smith will now set the motions to dismiss down so that those can be heard. And that will more closely clarify the lawsuit. Motions to dismiss, parties are basically saying, we shouldn't be here, let us out of the case. Or at least these counts shouldn't apply to us anymore, get rid of those. So depending on what happens with those motions to dismiss, some parties, I don't think it's likely, but some parties might exit the case because the judge agrees with their argument, or portions of the case may not apply to them anymore. But at the end of the day, it'll kind of it will more solidify who is in the case, and it'll tell those parties, buckle up and get ready for litigation if you're not going to settle. Because once the motions to dismiss are gone, now you get into discovery and you get into all of those issues, and now you're in the throes of litigation, and it's the stages going forward are more expensive, more timely, and you know you're in it for the longer haul. So that's where we are right now. I'm hopeful that Judge Smith will schedule those motions to dismiss soon so that that issue can be dealt with. We, as much as the defendants, will know exactly where the landscape will finally lay out for the parties, and then that will probably be a catalyst to get the parties back to the mediation table to see if now we can maybe make a little more headway, because now parties know exactly where their exposure is. With that, I don't believe, unless I forgot something, I don't believe that there's anything else. I will say I know many of you have asked about press coverage. I know there was the article in Go Local that probably many of you saw. Providence Business News also did, which maybe not as many of you saw, did an article. And there's also been some national, Pension and Investments is a national publication, and they've done a couple of articles recently on what's going on here. So the interest in what is happening here maybe is not at the fever pitch that it was in the beginning, but it has not disappeared and waned. There's still close scrutiny on what's going on, what's happening, and why it's happening. And with that, I will open up the floor, as I typically do, to questions. Does anybody have any questions?
What happened to their petition to move parts of this to Delaware?
Well, that was their motion to notice to sue and their motion for relief. What they were saying is we want to sue Charter Care Community Board, and we want to sue them in Delaware. And so, Judge Stern, you've indicated that the assets that CCCB holds that we'd be suing about are held for the beneficial interest of the plan. And so therefore that makes us think we might have to go on a motion for relief, motion to ask for your permission to go do it. That's what that motion was. So the result of that was no decision. Not yes, not no, just no decision at this point.
Who is it that will determine whether the ERISA insurance will be accepted? Is it the insurance company? Is it the courts? Who exactly decides that?
That's a very good question. And that is a question that unfortunately is a little up in the air. So there, according to the PBGC, which is the insurance group, there are only two bodies that can make that determination. The IRS makes the determination as to whether or not the plan qualifies, or a court can make a determination that the plan qualifies. Those are the only two. I have to ask for the IRS to do it, and obviously I've got to ask for the court to do it. We've already asked the court to do it. We're already traveling down that road. And I'm still contemplating what, if anything, I'm going to do with the IRS in that regard. There's the new director for the PBGC has just been, I think within about a week or two, was just confirmed. President Trump's appointment for the PBGC was just newly confirmed. So that agency is in a little bit of flux right now in terms of that change of leadership. And quite frankly, I'm not really sure how those federal agencies will view what we've been doing. I know as of now, all of them have received all of our pleadings. They're fully aware of what is happening. I am happy to say one thing I forgot to mention is when I made the election, Prospect asked for a conference with Judge Smith because this was new information. And essentially, the argument was that now that the election's been made, we don't even think the receiver has the authority to do anything with this anymore, that this is really it's either in kind of this limbo state or it's in the PBGC, IRS, and Department of Labor's hands. In what I would call just short of a miracle, we sent a letter to the PBGC setting forth Prospect's position on what my authority is post-election and asked them if they agree with it. And we got a response in less than 24 hours in writing saying, no, we don't agree with it. So that was actually, Prospect was saying that made a big change in the case and actually maybe even made mediation not a worthwhile endeavor last week. And getting that letter, I think we asked for it on Tuesday afternoon and we got the response on Wednesday morning. And provided that to the judge and provided that to the parties, and it kind of put that issue to rest. Not exactly sure why the PBGC decided to move so quickly. I'm glad they did. But one thing that came out of that, in addition to that letter, was an indication from the PBGC that they are not only aware of what's going on here and that they have been receiving the pleadings, but they've been reading them. They have been following this very, very closely. The person in charge that we spoke to was intimately familiar with the details of what's happening with this case. So this is, although we have not heard anything from them official in terms of a position or anything, and we've met with them prior to the election, so this isn't the first time we've spoken to them. Although we haven't gotten an official determination, we at least now know that they are very intently paying attention. And that's always a good thing, because that means that they know what's going on, and if they feel they need to come in at some point in time, they will, but as of right now, they're really just intently observing.